Commonwealth versus Patton lets us see how that there is an interplay between voluntary manslaughter and involuntary manslaughter. So in this particular case, the way the defendant chose to defend this case prevented him from being able to take advantage of the mitigation or the reduction of charges or the potential reduction of charges from first-degree murder to voluntary manslaughter. First-degree murder and voluntary manslaughter both involve an intentional killing of another person. But with voluntary manslaughter, we simply conclude that the intentional act was produced by something that caused reasonable provocation. We don't excuse the killing, but we recognize that a person presented with this scenario might be provoked to anger, and that we have a certain amount of sympathy for that person. And so therefore we would reduce the charge, or at least give the jury the option of reducing the charge from first-degree murder to voluntary manslaughter. And so the court in this case did not give the voluntary manslaughter instruction. And so the defendant on appeal challenges that. He said this case should have been charged this way. It of course is a terrible case. Any first-degree murder case is terrible, but this case is made even worse by the fact that the defendant in this case shot his own brother, and he's now going to spend the rest of his life in jail for killing his brother. And this, obviously, this since time immemorial, Cain and Abel, Romulus and Remus. This is, the story of historic myth and legend since time began. Here in this case, the defendant makes a claim that even though there wasn't an immediate provocation, that they had a number of quarrels before, and that Pennsylvania's version of voluntary manslaughter allows for the renewal of previous provocation, when confronted with similar facts from a person who previously has provoked the person to anger, to this degree of anger before. But the court says we don't even get there. We don't analyze that claim, because you didn't claim that you intentionally shot your brother. If that were the claim, if you said, look, I wanted to kill him, but I was provoked, then there would have been evidence in the record, perhaps, to have supported his claim. But the defendant, when he took the stand, he testified that he pulled the gun on his brother to scare him or to intimidate him, but not to kill him, and that the gun went off accidentally. And as the court said, that's not voluntary manslaughter. If the jury had believed his account, that would have been involuntary manslaughter. That would have been the defendant taking undue precautions with the way he held the gun when he held it on his brother. And so the key to this case, or the key takeaway from this case, is to understand that voluntary manslaughter has a whole lot more in common with first-degree murder than it does with third-degree murder. Third-degree murder is an unintentional killing, and first-degree murder is an intentional killing. Voluntary manslaughter doesn't, the claim that you make when you claim that you committed an act of voluntary manslaughter, you're not claiming that you accidentally or with lack of care shot someone. You are claiming that you intentionally shot someone, but that you were provoked. And that was not the defendant's claim in this case. He claimed that he pulled the gun on his brother, not planning to shoot, not desiring to shoot, but the gun went off accidentally. If that could either be a pure accident for which he would be not guilty, or the other offense that would be possible would be involuntary manslaughter, about which we're going to learn more. And that's taking an undue risk with the life of another person. It could also potentially be third-degree murder. As we'll learn, involuntary manslaughter and third-degree murder are difficult to distinguish. Both of them involve death flowing from an unjustified risk to another person, the only question being the degree of the risk that you take. So this case is not a case of voluntary manslaughter, because the defendant claims that he did not intentionally choose to kill his brother, that wasn't, he didn't claim he was provoked into killing. He claimed that he accidentally killed. And so there's nothing in the record to establish that the basis of his claim is that there was provocation in this case. So there's insufficient evidence in the record to justify giving the jury an instruction on voluntary manslaughter.